Okay, welcome back to class. We will start chapter 7. Here we're going to talk about defense attorneys. What are the learning objectives? We are going to be able to interpret the four major legal issues surrounding the right to counsel, discuss how the courtroom work group affects how defense attorneys represent their clients, explain why most lawyers do not represent criminal defendants, compare and contrast the three systems of providing indigents with court-appointed attorneys. Recognize possible tensions between lawyers and clients. Analyze the importance of legal ethics to the defense of criminal defendants. Let's look at some cases that has been decided by the Supreme Court. Gideon versus Wainwright. It was a 1963 case. Here, Clarence L. Gideon requested a court-appointed attorney, and it was refused. He was unrepresented by counsel, and Supreme Court sided with Gideon. Indigent defendants have the right to court-appointed counsel. It applies in felony criminal proceedings, and that decision sent shockwaves through the criminal justice system at the time it was rendered in 1963. The right to counsel is governed by the Sixth Amendment. The Supreme Court also extended the right to counsel to juveniles in a case known as In re Gort in 1967. In re means in the matter of Gort. Issues of right to counsel with non-felony criminal prosecution, stages of the criminal process, ineffective assistance to counsel, and self-representation. The right to counsel in non-felony prosecution cases also decided by the Supreme Court. In the case of Azazinja versus Hamlin in 1972, Scott versus the state of Illinois in 1979, and the state of Alabama versus Shelton in 2002. Stages of the criminal process under the right to counsel. The Sixth Amendment applies to all criminal prosecution, thus coined the term critical stages test. In the case of Memphis versus Ray, 1967, Miranda versus Arizona, 1966. Hope every one of you remember that, your Miranda right, the one that started with the right to remain silent. That was the case. And the next case was Corby versus the state of Illinois in 1972. The right to counsel, again, also apply once adversarial proceedings have begun. The sample cases brought forward by the Supreme Court, which I would like you to research and look at and read, is Brewer versus Williams, 1977, Rodri versus Gillespie County in 2008, Missouri versus Fry in 2012, and Lafleur versus Cooper in 2012 also. Right to counsel as it relates to the stages of the criminal process. During the custodial interrogation, the case that was brought up at that time was Miranda versus Arizona in 1966. The right to counsel again during police lineups is United States versus Wade in 1967 and Corby versus Illinois in 1972. As it relates to ineffective assistance of counsel, the court, in other words, the U.S. Supreme Court, used what is known as objective standard of reasonableness. The case that went before the court under that rule is Strickland versus Washington, 1974. The court looked at whether the counsel conducts undermine the proper function of the process. Did it render the outcome unfair? So the court ruled that the appellate court must reverse if proceedings were unfair, and the outcome would have been different if counsel had not been ineffective. And currently nowadays, only a few appellate court reversal on these grounds. Anyway, as it relates to self-representation, the defendant has a Sixth Amendment right to self-representation. Proceed. Missouri versus Fry, 2012. Lafleur versus Cooper, 2012. Faretta versus California, 1975. And limits. A limits must show judge the ability to conduct the trial, and a standby counsel also is available to the defendant during the trial in case the defendant representing himself is not doing a good job. Defense attorney and the courtroom work groups again. When it comes to attorneys or defense attorney, how do we define winning? Winning has to be defined as doing the best they can for their client. Either accepting probation, accepting a plea to a misdemeanor on the case, as long as they are serving the interests of their client, etc. Defense attorney and the courtroom work groups cooperate. They are all regarded as cooperative attorneys. What are the benefits of those? It makes it a kind of rewards, access to police reports and witnesses, and they could get sanctioned for indirect poor scheduling, dragging out a trial, and under the direct criticism, lack of assignment of some cases. And if it can work well with the courtroom work group, such as the district attorney and the judge, it could lead to a tougher plea bargaining. Variations in cooperation also exist. Inexperienced attorneys are regarded as gamblers because some of these guys just came out of law school. Public defenders, private attorneys with large numbers of defendants. Let's look at the criminal bar. In other words, we're looking at the criminal lawyers. There is diversity and stratification of the legal profession currently. Environment of practice, some of them maintain low status, difficulty in securing clients, and low fees. Providing indigents with attorneys. In other words, defendants that don't have the money to get a lawyer to represent them. The court will appoint a counsel or a lawyer for them. Who are indigent? Those are too poor to pay for an attorney and are entitled to have one provided for them for free. 3/4 of state prison inmates have a court-appointed lawyers. That's the current statistics. In urban courthouses, 82% of felony defendants are too poor to hire their own lawyer. It is up to counties to determine what type of system they will utilize. There are 3 systems existing currently right now to provide indigents with attorneys. One is an assigned counsel. Here, an attorney is appointed by the judge on a case-by-case basis. The second system is the contract system. Attorneys are hired to provide services for a specified dollar amount. The third system is a public defender. These are salaried public officials representing all indigent defendants. Assigned counsel, they are most common in small counties, and the criticism is that the attorneys are less qualified and they have inadequate pay structure. The contract system is mostly common in small counties. The criticism of the contract system is the lower standards of representation due to bidding when they bid for the contract. Private bar no longer plays an important role in indigent defense, and it was found unconstitutional in Arizona. Public Defender's Office, Los Angeles County in 1914. It started over there. Today, the public defender system represents approximately 70% of all indigents nationwide. Public or private non-profit organizations representing indigents, and funding occurs at the state or local level. Providing indigents with attorneys again under the public defenders. The proponent of the public defender agreed that we need to devote more attention to clients. We need more experienced and competent counsel, continuity, and consistency. The critics complain that the public defender's office are too tied closely to the courtroom work group. Defense attorneys' ethics. There are model rules of professional conduct governing defense attorney ethics, mostly written by the American Bar Association. They have a duty of candor to the tribunal, refrain from making any out-of-court statements, zealous representation is not allowed, abiding by client's decision only, act with reasonable diligence, confidentiality, avoid conflict of interest is the last one. So ladies and gentlemen, this is another short chapter, and that's the end of chapter 7, and now we will start chapter 8.